afraid? You gotta act out of fear. You can't be acting out of anger. That this guy won't stop and talk to you and won't obey your commands. Okay. What was there to be afraid of? Well, let's see. AHMAUD was wearing a t-shirt and cargo shorts that were so baggy he has this big belt loop out here. Let's see what else. Didn't have a bag or a backpack. So, yeah, doesn't have anything that he's carrying. He was running with his hands empty at his sides. Ran away from them for 5 minutes. Did not have any weapon. Nothing on him. Didn't say one word to them. Didn't threaten them verbally. Didn't say, oh yeah. Didn't say anything. And he had no help from anyone. So what's there to be afraid of? He went this way, goes this way, he goes that way. And you see Travis McMichael move down to the center of the street there, blocking his way. He's trying to get away, and then, oh, look, he's going to go this way. And he does. And he goes around. And what do you have here? Travis McMichael going to intercept. And that shadow underneath there, I mean, you have the stills back there. We printed some of them out. That shotgun is pointed right at him. Right at him. Okay? So when he gave the police that story about, oh, it was at Port Arms, and he was striking me and hitting me and striking me and hitting me, and I finally, had to do this. That's what he told the police. A bunch of lies. Shotgun, shadow right here. Okay? Here's the other thing, ladies and gentlemen. Lawyers aren't good at math. I don't trust you guys are. What did the ME say? This arm on AHMAUD Arbery was 26 inches. This arm on AHMAUD Arbery was 25 inches. And the barrel of that shotgun is over 28 inches. Do the math. Did he hit him? Did he punch him? Did he strike him? When the shotgun's like this? It's easy. Do the math.
Still with me, former federal prosecutor Nima Rahmani and trial attorney Sarah Flack. All right, Sarah, let me start with you if you could. Again, this is the last thing that this jury hears before they hear jury instructions, and then they go back to deliberate. Tell us, if you would, your opinion of how the prosecutor did during this rebuttal argument.
Well, Judge, I think Judge Ashley, I think Linda did a wonderful job, and this is really her strength. She is meticulous. She went through the law beautifully, and she really hit every single point, I think, that the defense made yesterday in each of their closing arguments. I loved how she broke down different statements and went through what AHMAUD did not do, especially in terms of self-defense. He didn't make any threats. He wasn't gesturing like he had a weapon. He's literally running. He's running away. At one point, the defendant runs towards Mr. Arbery. So she really hit each and every single point that the defense made, which is exactly what you want to do in rebuttal closing if you're the state, because you have that final word. You're the last thing the jury hears before they hear the law from the court and they go back to begin deliberation. So she nailed it. She really did.
Nima, do you have any opinion about how long an attorney should spend on rebuttal? And here's why I ask. She had 2 hours available. She announced at the end of closing arguments by the defense yesterday that she anticipated to take the 2 hours, and she did, in fact, take much of that time. Too long for a jury to listen, or does it matter how long it goes?
Well, you shouldn't go too long, but 2 hours is definitely appropriate in a case like this. You have 3 defendants, you have 9 counts, and you have a lot going on in terms of the facts. So let's go through what she did. I really liked how she really picked apart self-defense. You can't be the initial aggressor, right? We talked about that. You can't be committing a felony. That both undercuts self-defense and hits the McMichaels and Bryan with respect to aggravated assault and false imprisonment. I really like with respect to Roddy Bryan, as she talked about substantial factor and causation. I mean, Sarah talked about party or crime. All very highly effective and what needed to be discussed during rebuttal. But there's a couple of things she spoke about during rebuttal today that we haven't talked about that I think were very important. We've talked about the racial issues in this case, but this is also somewhat of a political case, not unlike Rittenhouse. And she talked about Travis's military service, right? That was a big issue in this case, him being in the Coast Guard and the training he received there. Obviously, Gregory is former DA investigator and law enforcement. And she said, this isn't a case about the McMichaels being good people. people. This has nothing to do with it. This is about the facts and circumstances of this case and their decisions on that day. So I really like what she did there. And another thing that she talked about, which was very effective, is that AHMAUD ARBERY has a right to be free from folks who aren't law enforcement, who don't have badges, who aren't wearing vests, who aren't in marked vehicles, stopping him and asking him questions. They have no right, and he has a right to walk away or to run away. And I think that's going to resonate for a lot of jurors that may not like, too much government involvement in their daily lives, or they like their civil liberties. So two very important themes that she also addressed today during her rebuttal, and I think she did an outstanding job.
Sarah, let's pivot a little bit. Are you surprised or not that no one requested that this jury be sequestered during deliberations?
I am. I'm very surprised, especially in light of what the judge indicated to us yesterday, or I guess this morning, about what happened yesterday when he spoke to the jury privately in the back and had heard from the jury room some shouting or protesting, I guess, going on outside the courthouse. I'm surprised that at least during this portion of the trial that there wasn't a request, especially because of some of the requests that have been made by the defense lawyers in this case thus far. But I will say that typically if a jury is not sequestered through the whole trial, rarely do they just sequester them for this portion of the trial. But still, because of this high-profile nature of this case, I'm surprised at least one of them didn't make that request.
And it's been interesting to hear some of the defense attorneys comment on that piece. And just a reminder, it's a Brunswick County, Georgia, jury, right? They didn't have it moved. Nobody asked to have it moved, or here it was. And so it's a community that has provided this jury that's deliberating now. You're both going to stay with me. We want to take a moment to look ahead to an upcoming case for Court TV. This is a trial from Minnesota versus Kim Potter, the former police officer who says she mistook her gun for a taser during the traffic stop of Dante Wright. Potter is charged with first and second degree manslaughter. Court TV cameras will be in the courtroom when jury selection begins later this month on November 30th. The trial is then scheduled to start on December 8th of this year. You won't want to miss a thing. Roddy Bryan's attorney, Kevin Goff, has become a lightning rod in the Arbery case. Coming up, we're going to take a look back at his most provocative moments during this trial.
This is Drive Time, where you have a 99% chance of getting approved for a car, even if you don't have great credit. You may even qualify for $0 down.
Awesome, because my credit is...
Great. That's why we built the Smart Approval Machine, or SAM.
Hello. Is this a real machine you guys use for approvals?
Oh, no. These buttons don't even work. You get approved on your phone.
SAM is for fun, ha ha.
We use a ton of different factors to get you approved, not just your credit score.
I got approved.
I told you, 99% of people do. Go to drivetime.com, get approved, and see if you qualify for $0 down. Drive Time. Genius.
Do you owe money to the IRS? Listen to how Optima Tax Relief helped these people put their tax debt to rest.
I owed the IRS $102,000.
I owed the IRS $66,000.
It's a horrible feeling. At some point in time, I knew the IRS was going to be coming looking for me.
I was paralyzed with fear.
Optima got me a settlement with the IRS.
The team at Optima Tax Relief settled my IRS tax bill.
It was every bit of a new lease on life for me to be able to get that burden off my shoulders.
They really cleared the path for me to have a fresh start, and I will be forever grateful.
And I'm still amazed. Tell the story. People do not believe it, and I have paperwork to prove it.
For your free consultation, call 800-648-4559. That's 800-648-4559.
Optima Tax Relief.
Use code TV14 for 14 free meals plus 3 free gifts during our Black Friday sale.
Experience the wildest true crime ride-along with Oxygen. Strong women,
how many other victims are out there.
With real convictions. Oxygen. We live and breathe true crime.
Hi, Jimmy J.J. Walker here. If you're on Medicare, listen to this. It's the Medicare annual enrollment period, and there's a deadline to update your coverage and benefits for all of next year. I didn't want to miss out, so I called the 1-800 number to see what Part C benefits I could get. An actual person answered and looked up my zip code, and boom! I was offered extra benefits like dental care with extractions, fillings, dentures, transportation, and so much more, all at no additional cost. And get this, based on my zip code, I can get $100 a month. That's $1,200 a year added to my Social Security check. I was like, dynamite! Call, check your zip code.
I called, and he looked up my zip code and said I could eliminate co-pays and get expanded dental care, prescriptions, transportation, and meals covered at no extra cost.
I couldn't believe my zip code has a benefit that adds money to my Social Security check. They help me so much.
It's simple. 1, call the number on the screen. 2, the agent will check your zip code to see if you're able to eliminate co-pays, get expanded dental coverage, prescriptions, transportation, and meals. And 3, they will check to see if you're eligible for the benefit that adds money to your Social Security check every month, up to $1,700 a year. Call to check your zip code and get what you deserve.
I called to check my zip code.
I called to eliminate copays.
I called to save money.
I called to get my dental work covered.
I called to get money added to my Social Security check.
Call, check your zip code. Don't miss the deadline. Call now. It's free.
Call 1-800-989-5137. That's 1-800-989-5137 now.
Now in hour 4 of the verdict watch in the murder trial of 3 men accused of killing AHMAUD Arbery. This high-profile case has captured the attention of the entire nation, and so did one of the attorneys in this trial, Kevin Goff, who is the defense attorney for the defendant, William Rowdy Bryan. He's managed to stay in the spotlight with some of his controversial trial motions and comments. Let's take a look at some of his most polarizing moments in the courtroom.
He's basically inviting jurors to just, like Dorothy, there's no place like home, there's no place like home, there's no place by home. We're indoctrinating jurors to say, I can be fair, I can be fair, I can be fair. What at first looks, when we all come in the courthouse on Monday morning, like a very innocent attempt by a civil rights group to promote voting rights, turns out to be something much different.
The court does not find that the movement has met its burden to limit the First Amendment rights of any individuals that may come to the courthouse grounds, which is a public place.
In this case, it would appear that white males born in the South over 40 years of age without a 4-year college degree, sometimes euphemistically known as Bubba or Joe Sixpack, seem to be significantly underrepresented. I can't say underrepresented in the entire panel of jurors because the race information on the master list is obviously not inaccurate. There's a real question in this case whether that demographic is underrepresented in this jury pool. And if it is, then we have a problem with it. One issue, we renew our objection for service for the record proceeding on Veterans Day. Compelling jurors to serve on this federal holiday, we would contend, is a violation of the jurors' rights. Whether they have formally filed objections or not, we don't know whether they know. They can tell the court if they have an issue, like if they have daycare, but it takes on a different kind of context. We maintain that it is illegal. Yeah,
I believe I've already addressed that. We're here.
The Right Reverend Al Sharpton managed to find his way into the back of the courtroom. I'm guessing he was somehow there at the invitation of the victim's family in this case. And I have nothing personally against Mr. Sharpton. My concern is that it's one thing for the family to be present. It's another thing to ask for the lawyers to be present. But if we're going to start a precedent starting yesterday, we're going to bring high-profile members of the African-American community
into the courtroom to sit with the family during the trial in the presence of the jury. I believe that's intimidating, and it's an attempt to pressure, could be consciously or unconsciously, an attempt to pressure or influence the jury.
So I'm not going to blanketly exclude members of the public from this courtroom. If individuals, based on the limitations that we have in the courtroom, end up sitting in the courtroom, and they can do so respectful of the court's process and in compliance with this court's orders with regard to the conduct of the trial, and they're not a distraction, then I'm not going to do anything about it.
How many pastors does the Arbery family have? We had the Reverend Al Sharpton here earlier, last week, and I'm not keeping track, and I think the court has indicated the court doesn't intend to ask anyone to keep track of who was in the gallery. But I don't know who Mr. Reverend Jackson is pastoring here. We are concerned about whether it's conscious or unconscious, the impact of their presence with respect to the jury and with respect to the proceedings in this case. And I guess the next question is, which pastor is next? Is Raphael Warnock going to be the next person appearing this afternoon? We don't know.
Mr. Goff, at this point, I'm not exactly sure what you're doing. I have already ruled on this court's position with regard to the gallery. The court's position hasn't changed. At this point, it's almost as if you're just trying to continue this for purposes other than just bringing it to the court's attention. And I find that objectionable from the court standpoint. I have said over and over and over in this trial that I am attempting to ensure that in this courtroom that the defendants receive a fair trial, and I will continue to do that. I have heard the objection. I have ruled previously on my position with regard to the gallery, and that is unchanged.
Still with me, former federal prosecutor Nima Rahmani, also trial attorney Sarah Flack. Nima, let me start with you if I could, because Sarah and I had discussed a little bit earlier about whether or not anyone should have asked that this jury be sequestered, which we know no attorneys requested. What are your thoughts?
Yes, Ashley, this is all gamesmanship, and we see what Goff is trying to do with respect to the black pastors. He doesn't want any influence on the jurors. Well, this is gamesmanship by the defense here. Normally, they want to change a venue. They want to get this out of Glynn County, but they like that conservative jury pool out there in Glynn County, and this is why I think they don't want the jurors to be sequestered, because sequestration puts a lot of pressure on the jurors to return a verdict. Right? They want to get home to their families. They don't like being figuratively locked up without access to their cell phones. So what these defendants want and their attorneys is maybe one or two holdout jurors, and they don't want the pressure of sequestration because they think that will help the prosecution, because they know they're behind in this case, and it's going to make the chance of them getting that 1, 2, 3 holdouts hang in this jury less likely if all the jurors are sequestered.
Yeah, good input, good insight as to why you think they didn't ask for the jury to be sequestered. Let me ask you, Sarah, do you think that Goff went too far, that he raised his motion for mistrial one too many times, and did he push Judge Walmsley too far in this case, in your opinion, or was it zealous advocacy for his client?
Oh, no, it was not zealous advocacy for his client. This was too far, and this is spoken from a defense attorney who I do this very same thing that he does every day. But where he went, I mean, to say that you don't want African-American, high-ranking members of the African-American community, that there's almost too many of them in a courtroom, that has nothing to do with anything. In fact, every single day in courtrooms all over the country, we could make that same argument that there are too many people of an opposite color of what my clients are charged with. But we don't make that argument because it's not legal, it's not logical, and it makes no sense. And so for him to inject that sort of thing into this case, when we're already dealing with very sensitive issues related to race, it just blows my mind that a defense lawyer would do that. There's just nothing, there's no basis to do it, and I think he's lost credibility. I think we saw the judge all but scold him for doing it and continuing to do it repeatedly throughout this trial.
And the state pointed out that by being in the courtroom, they weren't creating any distractions or doing anything inappropriate as members of the public, which is very significant as well. All right, Nima Rahmani, Sarah Flack, thank you both for joining us today. We so appreciate all of your expert analysis. This is it for me for the week. We're wishing you all at home a safe and happy Thanksgiving. Of course, I'm grateful for you and all of our viewers in the UK. Stay seated, though. Up next, Michael Ayala. He'll be in my seat, the anchor chair, to have the latest out of Brunswick, Georgia, in the case of AHMAUD Arbery.
Tonight on Closing Arguments, we are in a verdict watch in the killing of AHMAUD Arbery murder trial. Was the prosecution able to convince this jury to convict all three of these defendants?
Closing Arguments, tonight at 8/7 Central, only on Core TV. Sometimes evil.
He was a man who kept himself to himself.
Is closer than you think.
How could this happen?
Evil up close. Marathon begins Friday morning, 9/8 Central on Core TV.
Hi, folks. Medicare open enrollment is simple. 1, call the number on your screen. 2, the agent will look up your zip code to see if you're able to eliminate copays and get Part C benefits like prescriptions and expanded coverage for your dental work at no extra cost. 3, they'll check if you're eligible to get money added to your Social Security check up to $1,700 a year. Call to check your zip code.
I call to check my zip code.
I call to eliminate copays.
I call to get everything I deserve.
I call to get money added to my Social Security check.
Millions of people have trusted the Medicare coverage helpline. You can too. Call the 800 number on your screen to check your zip code. Don't miss the deadline. Call now. It's free.
Call 1-800-337-3200. That's 1-800-337-3200 now.
Meet Martha. Martha is 75 years old and has been on traditional Medicare for 10 years now. But she's a bit cranky because she heard the 2022 Medicare Advantage plans are now available during the Medicare annual enrollment period, and she wants details.
I'm already on Medicare. Where's my additional benefits?
Hi, Martha. Millions of Americans like you may not be getting all the Medicare benefits that are available to them. Now is the time for everyone on Medicare to call during the Medicare annual enrollment period for your free 2022 no-obligation Medicare benefits review.
I already have my Medicare card. I am not calling.
Martha, right now is the Medicare annual enrollment period. 2022 Medicare Advantage plans are now available, so everyone on Medicare can call to see if they can save money or get additional benefits.
They probably won't answer the phone.
Well, Martha, if you call 800-781-9406, a licensed insurance agent will speak with you and look up your plan and see if you qualify for a plan with additional Medicare benefits.
Why don't I get these automatically?
Martha, right now is the Medicare annual enrollment period. 2022 plans are now available, so now's the time to call.
I think I called last year, so I'm not calling.
Martha, 2022 plans are now available, but you won't get additional benefits automatically. So everyone on Medicare should call now during the Medicare annual enrollment period and get your Medicare benefits review today. Just call the toll-free number on your screen. It's free.
Free?
Yes, Martha. The call and no-obligation Medicare benefits review are free. They can look up your plan and let you know if you're eligible for additional benefits and see if you can save money.
Why didn't you say that sooner? It's time for me to call and get my free no-obligation Medicare benefits review.
That's right, Martha. I should have just given you the toll-free number. It's on everyone's TV screen now. Call 800-781-9406. 800-781-9406.
Hello Fresh. And use code TV14 for 14 free meals plus 3 free gifts during our Black Friday.
Hello,
Welcome back to Court TV Live. I'm Michael Ayala. Thank you so much for joining me this evening. We have breaking news in the trial of the men accused in the killing of AHMAUD Arbery. The jury is now deliberating. They've been weighing the case now for about 5 hours and 6 minutes, actually 7 minutes as of that second. Now, the case was given to the jury after prosecutor Linda Denikoski delivered her state's rebuttal argument to the jury. Take a listen to some of that.
Ladies and gentlemen, here's the thing. This isn't about whether these three men are good people or bad people. That's not what this is about. It's about responsibility. It's about holding people accountable and responsible for their actions. When they do something like this, they have to be held accountable and responsible. Nobody gets a free pass. Okay? Would you get a free pass? Who gets a free pass? No. The law basically says if you commit the crime, you're going to be held responsible. And ladies and gentlemen, when you come back with a guilty verdict on all the charges, this isn't saying somebody's a good person or a bad person. What you're saying is, you know you committed the crime. Now we know you committed the crime too. That's all it is. They know what they did. It's not like they don't know what they did. They know exactly what they did, and they know why they did it. It's not a mystery to them. When you come back with your guilty verdict, all you're doing is telling them, we know what you did too. And we're going to hold you responsible for it. Because guess what you did? You turned this young man into that young man. That's what you did. For absolutely no good reason at all. Ladies and gentlemen, I'm asking you to find all three defendants guilty of all the charges in the indictment. Thank you very much.
You know, when Linda Denikoski was referring to this young man and that young man, she had pictures up, one of him with that well-known high school photo and then one of him, of course, after the incident. All right, let's bring in Court TV legal correspondent Julia Janae, who is live outside the courthouse in Brunswick, Georgia. All right, Julia, let's get a quick rundown of the charges this jury has been considering for the last 5 hours and 9 minutes.
So, Michael, they are deliberating, like you said, for 5 hours. We just learned that the judge is going to check in with them around 5 o'clock, which is right now. So we may be getting word at any point whether or not they want to keep deliberating, whether they have any questions, or if they are going to go home for the night. The charges they are considering, there are 9 of them. The first one is malice murder, and the sentence range for that is life or life in prison without parole. They also face counts 2 through 5 for felony murder, and those also carry the same sentence, life or life in prison without parole. This is not a death penalty case, so that's the maximum in Georgia. Count 6 through 7 of the indictment is aggravated assault. That carries a sentence of 1 to 20 years in prison, and then false imprisonment. That carries a sentence of 1 to 10 years in prison. The last count of the indictment, criminal attempt to commit a felony, 1 to 30 years in prison. So that top count is what carries the life or life in prison without parole. The judge instructing these jurors, they are not to consider sentences or even think about it in their deliberations. That's something that will happen through the judge if there is a conviction in this case. All right, good to know there, Julia. And where did the court land as far as lesser included charges? How many were included in what this jury will consider? This only applies to William Rodney Bryan. He asked for these lesser included charges. He only got 3 of the 4 that he asked for, but here's a look. Simple assault, reckless conduct, reckless driving. These will come under the aggravated assault charge. So that verdict form that this jury will get for William Rodney Bryan will look a little bit different because there will be other options that they can choose. These other defendants, Gregory McMichael and Travis McMichael, they did not ask for any lesser included charges, and it seems the state and the judge did not believe any needed to be on this verdict form. So those charges are what they are as far as those 2 defendants are concerned as the jury deliberates this. All right, now, Julia, an important issue in this case is the issue of what knowledge the defendants had and when they got it, and how that applies to this idea of citizen's arrest. So tell us what this jury was told about contemporaneous arrest and whether the defendants could use prior knowledge of illegal activity to justify that citizen's arrest. Michael, this is a huge issue in the case. I think it's one of the most challenging parts for this jury to come up with. These parties have battled it out. And like you said, knowledge, immediate knowledge is what's said in the citizen's arrest statute here in Georgia that has since been repealed. If the person who wants to effectuate a citizen's arrest wants to or believes that someone has committed a crime, that crime has to be committed in their immediate knowledge or in their presence. But there's also this charge, the contemporaneous arrest instruction that has been given to this jury. And it tells them that a private citizen's warrantless arrest, a citizen's arrest, must occur immediately after the perpetration of the offense or, in the case of a felony, during escape. If the observer fails to make that arrest immediately after the commission of the offense or during an escape, in the case of a felony, his power to do that citizen's arrest is extinguished. The prosecution's position is that this should not be something that applies to this case as far as their right to carry out a citizen's arrest, because they say it didn't happen immediately enough. But the defense says they can take into account more than just what happened immediately that day. And they believe that probable cause charge that was given to this jury, or instruction, where they were told they can look at a totality of the circumstances to come up with probable cause. I'm sure the defense is hoping this jury relies on that instruction more than they do the one on contemporaneous arrest.
Yeah, those two seem to be at odds a little bit. An interesting dilemma, I think, for this jury. Wouldn't be surprised if there's a question about it later on. Now, the judge today addressed an issue, Julia, regarding where the jury would be located for deliberations. What happened there?
Right. This actually came up first yesterday. Judge Timothy Walmsley was talking about what was going on outside because it was raised by one of the attorneys. And we have a look at what we saw yesterday as far as the organizations who were here, which was a change from what we have seen. We saw the Black Panther Party was here, and they were carrying rifles. And that's something that came up as an actual mistrial motion from Kevin Goff, because he said this is changing the dynamic outside. It could influence the jury. They are marching around this courthouse. So here's a listen to what Judge Walmsley said he learned after he did inquire of the jury as to how much influence or what they knew about what was going on outside.
So when I walked in, I could hear some noise outside. It's muffled. You can't really hear it. But I was listening for it because it was the first time I've been in that room during, really, the proceedings. I heard something and did, in fact, say, "Oh, have y'all been hearing this?" And the response was, "Oh, we just heard that." That's it. So, no. And it's muffled. You can't actually hear what it is. You just hear there's a commotion. What I heard was just, it apparently, right as I went into the room, a group went around the side of the building. So it was on my radar, and just for the record, heard it. And no, it is not. It is not. I understand the concern, and I'm understanding where we are with the case. I thought I'd put it on the record simply to say, here's what we're doing. But no, they're not being moved because there's a commotion outside. They're being moved because I thought, based simply upon that and me hearing that, it was in the best interest of the court to go ahead and put them into one of the courtroom's interior.
And Michael, as you know, I was inside of the courtroom yesterday during this protest outside. When I was inside, I could not hear anything that was going on, but it was very clear once I got outside, I could hear the chants of no justice, no peace. It was very clear. So if this jury is only hearing that there's some sort of muffled sound, then that would indicate that they don't hear what's going on, because it's very clear when you're outside what the chanting is and those words that are being used.
Yeah, but I still suspect we'll hear something about that if there are appeals in this case. Now, Julia, prior to deliberations, of course, the alternates were chosen. Fill us in on that process and what this final jury of 12 looks like.
This jury has been separated out. They did not know that they were alternates, the three men and women who were listening to this trial, listening to the evidence. But the judge did announce that today. Here's a look at the breakdown of that jury. There's 12 people on the panel. There are 11 white jurors, 1 black juror on this panel. There are 3 men, 9 women. We know that they range in age based on their appearance from 20s to their 60s. As far as the alternate jurors, there's one man and two women, and the actual alternates that were dismissed, well, not dismissed, but they are not going to be in the deliberation room. They range in age from their 30s to their 60s. So that does change the makeup just a bit when it comes to gender. We have let's look at the alternates. A white woman in her 50s to 60s, white man in his late 60s, white woman in her 30s to 40s. There weren't many in their 20s to 40s on this jury to begin with, so losing one does continue to skew the age of this jury older. Here's a look at two of the jurors who are in there deliberating right now. One being the African-American male who's on this jury, who's been the subject of conversation when we talk about diversity on this jury. He's a black man in his 60s, has a relative who works for the Glenn County Sheriff's Office. He told these attorneys during jury selection that he travels for work regularly and has personally experienced discrimination, describes himself as old school, says he doesn't use a computer or social media. Here's another of those jurors who are deliberating right now, juror number 258. He's a white man in his 60s, a retired federal law enforcement officer. And about the shooting, he said, after doing this for so long, it's really not shocking to me. He's served on a jury before and testified in court in the past. Michael, I'm curious to see, once we get a note, if we can tell who the foreperson is, whether or not it's the woman that I saw taking a lot of notes when I was inside, or if it's going to be this former federal law enforcement officer.
Yeah, that should be interesting. All right, now, Julia, finally, what are the rules for deliberations? Do they have all the videos with them? Will they have to ask for them and then watch them in open court? And how long can they deliberate each day?
Well, the judge did say that, as is typical, they are not going to get any of the live ammunition or firearm in this case, and they also aren't going to get the videos back with them. But with the videos, they can ask, they can request if there's a portion that they want to play back, and the court will play that back for them. So they're not able to, by themselves, go frame by frame through some of these videos. We will know if they want some of the video. And as far as how long they can deliberate, it's really up to this jury. They will tell the court at exactly what time they want to stop deliberating. And like I mentioned, we're supposed to know that any day now, or any time now. I'm looking now at my phone. I don't see that we have any information yet on how long the jury wants to deliberate today, but they will let the court know.
All right, we'll be keeping an eye out for that. Julia Janae, thank you so much for that report. Always appreciate your reporting. I'm going to let you go now and bring in my guest for this hour, former criminal defense attorney Lauren Prater. Lauren, great to see you again. Thanks for being on the show.
Thanks for having me.
All right, a lot going on today, right? So first and foremost, the thing that jumps out at me is the last thing that Julia said. They don't have the videos with them. And all along, you know, this was a case that we thought was all about the videos, but it's been 5 hours of deliberations, and they haven't asked for the videos. So what do you think's going on there?
Well, I think that the prosecutors gave them a lot to think about. One thing that I thought was really interesting was that the defense didn't fight a little bit harder to keep going and get everything out last night. I think the fact that the defense had the last word yesterday, and then the prosecutors got to dig into the jury first thing in the morning with fresh minds. I think they're probably really looking at the points that were brought up, really looking at the actual evidence that's been presented, probably going through their notes and just really reevaluating on what they've seen thus far. So I think they definitely have a lot to chew on, a lot to digest. I don't think that the videos are the only thing that would cause a stir up. But I think the prosecutor did a great job, and they're probably just going through everything thoroughly, which as a defense attorney, we want, you know, but as a prosecutor, I'd be like, oh gosh, this should have happened a lot quicker. I would like to think that it would have happened a lot quicker verdict.
Yeah, there's a lot to go through. I didn't think this would be a quick verdict at all. You know, there's a lot of definitions. And like I said, at one point, I thought this was all about the video. It was right there. But then slowly but surely, as this case went on, it became about all these different definitions: probable cause, citizen's arrest, contemporaneous arrest. Those are all things that you got to parse through. 9 different charges for 3 different people. So, you know, there's a lot of work to be done. So I'm not necessarily worried about that. But I want to touch on something that you talked about, the fact that there was a rebuttal argument given given. And I want you to explain to our viewers just how important that is. That is such a powerful tool of the state, to be the last folks to speak to the jury. And they decided not to do it last night, but to do it today, which, I don't know, I thought giving the defense the last word yesterday might have been a problem. Maybe they wanted to be the last word yesterday, but then also the idea that they're speaking to a sort of fresh jury in the morning could have been part of their decision-making as well. Your thoughts?
Yeah, the jury ended so late last night. I mean, I would have been exhausted after having all of that information thrown at me in closing arguments. And I know, obviously, the jury wants to do a good job. They're taking notes, they're paying attention. But I think there was some mention that one juror, they had concerns that they were falling asleep. So I think it was definitely to the prosecutor's best advantage to say, listen, call it a night. Let them think about whatever they want to think about overnight. But you know what? In the morning, when they're fresh and when they can actually, use an energized mind and a fresh eye and a fresh ear to evaluate the evidence, the prosecutor got to lay in on that and take great advantage of it. The fact that she gets the last word is huge. As a defense attorney, I absolutely hated that, because essentially I can go out as a defense attorney and give my best job, and they still have an opportunity to take the night to go over and rebut everything that I said. I mean, she had all night to go through every last bit of argument that the defense put forth and come up with something to defend it. And she did that today, and she did an incredible job.
Yeah, I would honestly say that I'm pretty sure she was up all night working on it, because, as you said, she did a fantastic job. But we're going to take a look at that as we come up throughout the hours. So stand by, Lauren. Thank you so much for those insights. When we come back, we're going to break down the state's rebuttal arguments. Prosecutor Linda Dunikoski breaks down reasonable beliefs in this case, an important point. And then later in our Talk Back segment, did the state prove beyond a reasonable doubt the charge of malice murder? That's the top charge, life in prison. Let us know what you think. Share some of your responses later in the show. So keep it right here on Court TV, your front row seat.
George Foreman here to fight for you and make sure you're getting a Medicare Advantage plan with all the benefits available to you. That's why you need to know the Medicare and prescription drug plan annual enrollment period is now open.
George, does that mean I can update my Medicare plan?
That's right. Now's the time to call to update your coverage and see if you are eligible for new Medicare Advantage plans that may include dental, vision, hearing, and prescription drug coverage.
Did you know that you may be eligible to get up to $144 added back to your Social Security check every month? It's easy to see if you're eligible. Just call the toll-free number on your screen now and get a free Medicare benefits review. Just call 800-718-1984 now.
George, I keep hearing we don't automatically get new Medicare benefits. Should I call to see if I'm eligible?
Yes, you should do what I did. I made the call and spoke to someone who was so helpful. Just call the number on your screen.
Call now to see if you're eligible for plans with additional benefits, like free eyeglasses, free hearing aids, free rides to appointments, free telehealth visits, or even an over-the-counter allowance.
Plus, you could be eligible to get money added back to your Social Security check every month. Now that's a knockout.
George, do you think I can really save money and get extra benefits?
I'm so glad you asked. You may be eligible for a plan with $0 premiums, $0 deductible, and no co-pays. Don't miss out. These are the final weeks to enroll, so make the call now.
Thanks, George. I'm calling right now.
I made the call, and you should too. There's no obligation to enroll. The call and Medicare benefits review are free.
Just call 800-718-1984 now. That's 800-718-1984.
Hi, I'm on Medicare, so before the deadline, I called to see if I was missing out on any extra benefits and if I could really get money added to my Social Security check. The agent said I'm eligible to eliminate copays and for Part C benefits, including meals, prescriptions, and dental coverage, all at no extra cost, plus $1,500 a year added to my Social Security check. I was like, wow, thank you. You can call too.
I called to eliminate copays.
I called to check my zip code.
I called to get my dental work covered.
I called to get money added to my Social Security check.
Right now is the only time of the year you can update your benefits. Call the 800 number on your screen to check your zip code and don't miss the deadline. Call now. It's free.
Call 1-800-640-8152. That's 1-800-640-8152 now.
Think of everyone you know, your friends, family, coworkers, everyone. Now, what if one of those people wanted you dead?
Someone They Knew with Tamron Hall, premiering January 9th on Court TV.
Why do we have bureaus in Missoula, Nashville, and Tulsa? Because we want to tell the whole story and elevate voices from all over the country.
It's about the whole community stepping up to help.
Music,